session is very, we'll try and make it spicy. So before I call the rest of the speakers, I have a story. Just 2 minutes. My name is Geoffrey, and I am honored to be in New Delhi. This is my first time here. Let me start by telling you something that you all do not know about me. Something, when we are back at home and I tell my colleagues, they laugh a lot. And it's because I watch a lot of Bollywood movies. Yes, very diligently. In fact, you know, with the subtitles and all, whether in Tamil language, Telugu, Hindi, I am very diligent in following the stories. And while some colleagues, of course, may tease me about it, over the, top fight scenes, where a single punch sends like a dozen of people flying, and sometimes defying the law of physics, I remind them that it's all part of fun, and I ask them, if it's about entertainment, then why not add a little bit of spice into the action? But for me, more than anything, Bollywood movie isn't just about the fight scenes. It's about the stories. It's rich, layered, and often deeply very relevant. These films tackles issues that resonate globally, like governance, corruption, business growth, socioeconomic challenges that we face. From famous actors such as Amir Khan's inspiring tales to Priyanka Chopra's bold character, Shah Khan's timeless charm, and Ashke Kumar's social commentaries. Bollywood blends entertainment with powerful messages. And of course, let's not forget the music. After all, where else do you pause mid-story for beautifully choreographed song before diving into the drama? So for me also, if you go to my Netflix account, the machine learning algorithm always recommends the latest Bollywood movies that have been released. So I am keeping up with the latest movies. Also, when we are coming to New Delhi, and I was telling my colleagues what I usually do when you are on a long flight. Just go to the movie selection, go to the list that has the Bollywood movies. Most of them are between 2.5 hours to 3 hours. So if you have a journey of 6 hours, you only need to watch 2. And by the time you are done, you'll be in your destination. So I am privileged today to moderate this session on the role of citizen movement and digital tools in shaping economic justice, where together we'll explore issues on AI and its growing influence on digital tools in activism, issues such as digital internet shutdown and how it threatens democracy, and other relevant topics that have profound impact on our society. So again, without further ado, Dimas has already introduced himself, and Ma'am Rama Devi. So allow me to call the rest of the panelists. So allow me to call on stage Apar Gupta, Observer Trustee from the Internet Freedom Foundation, and Siddharth Sijoria, Advocate and Young Lawyer from the Commonwealth Lawyers Association, and is also committee member representing India. And because I will seek your indulgence, the third session, 2 of our panelists will not be available, so that we do not have a panel that only has 1 speaker. I will also invite the Honorable Lady Justice Jemima Kelly to be part of this panel, to also bring the constitutional angle of what we are going to speak about. So thank you very much, our esteemed panelists. I will start with Ma'am Rama Devi, who is an expert in AI. Across the global south, we have seen citizens taking to the streets, and online platform has really been a platform where people express their frustrations and also try to advocate for issues to be addressed. For example, in Kenya, the recent rejection of the finance bill saw a lot of people going to platforms such as Twitter, WhatsApp messages, trying to mobilize and highlight the power of the collective action. So from this and the work that you are doing from Telangana State, kindly, while you also touch on issues of digital tools, how would you speak on how Telangana State is using digital tools, specifically AI, to empower marginalized groups to promote economic justice?
Yeah, yeah. Well, thank you for having me here today. It's my privilege to be here to share our experiences in Telangana, how we are using digital technologies, more so emerging technologies to improve lives, to solve social problems. As Jeffrey has mentioned, citizen movements have been in place for quite some time. It's the order of the day in the sense, that's the only way it has been to amplify marginalized voices, to actually, bring biggest issues to the notice of the government. Citizen movements have started. But citizen movements, coupled with digital technologies, will amplify voices, bring in, policy changes within the government, ensure accountability by the governments. And these digital technologies are being used by many countries, especially in the global south. We have seen a few of them, like, in fact, within India, like in 2021, farmers have used chatbot to actually, it's the biggest movement by farmers in India. They've used chatbot to actually, send their messages out there, mobilize people, and finally the government had to roll back reforms based on the request of the farmers. That's one case in India. While, and we have seen in other countries as well, for example, Brazil, they use AI to actually analyze, budget spending by the government and see where anomalies are happening. Thirdly, we have seen the Me Too movement. As a woman, I was really impressed with that kind of movement, where stories came out, from different parts of the world by women, the harassment they face at workplace and so on. So these digital tools are being used to amplify, voices of the marginalized communities, to highlight issues, economic issues faced by different sections of the people and so on. But today what I would like to share is how, the government of Telangana is using digital technologies to improve lives. Why are these citizen movements happening? Why are these activists, taking out onto the streets to actually, because there is a problem that exists out there, it's affecting millions of people, marginalized communities, poor people, and so on. What if, you actually solve these problems? So then you don't have to have citizen movements, right? That's what we are doing in Telangana. We have set up a separate division called Emerging Technologies Division, way back in 2018. We call it the Industry 4.0. This is the fourth industrial revolution that is happening in the world after the three industrial revolution. And this is a tech revolution where, these new age digital technologies are actually being used by companies, governments across the world to solve problems. We thought, why don't we also focus on these technologies to see how we can solve problems in our communities, problems of our people, our citizens, and so on. So I'll share a few examples how we do it. We actually reach out to different departments. It could be an agriculture department, it could be health department, it could be, a department, social welfare department that transfer benefits to poor people, to understand, what are the problems that they're facing, where they're not able to deliver services to the citizens, to the marginalized groups. We understand, in technology, we call them as use cases, while in general terms, they're called problem statements. So what are the problems that they're facing in terms of delivering the service? So we identify those use cases, and then we see whether technology can be deployed to solve that problem. So to give you a couple of examples, like, agriculture is one of the largest profession. 60% of the population depend on agriculture. And most of the people who are in that occupation are very, small holding land farmers. They own just 1 or 2 acres of land. And it's very difficult for them to make their both ends meet with the income that they generate from agriculture. That was the reason, the farmer protests were there earlier in the country. We thought, can we use technology to increase their income? Because they're not able to meet both their ends. Even there are certain cases of suicides also where farmers, because they're not able to earn enough money, they are in debt and they're actually, committing suicide. So we actually, sat with the entire ecosystem in agriculture, with the foundations, with the industrialists, with the governments, with civil societies, and try to understand what are the top problems that the farmers are facing. So number one, certain problems we identified, top 5 or 10. For example, most of the farmers, while sowing seeds, they don't know what to sow. I mean, they just go by what they do, they have been doing for years without understanding the soil nutrition, without understanding the market prices, without understanding the weather conditions. So we are actually using AI to provide those advisories to farmer based on the demand, based on the weather conditions, what kind of plant they need to sow. And once they sow, most of the times, they also are not able to protect their plants from pest infection. So we use AI tools to advise them in advance, In fact, this particular AI tool that we use for cotton farmers has been appreciated by Google CEO, Mr. Sundar Pichai, when he was in India, 2 years back. So those are the kind of tools that we are developing and, advocating for farmers. And in fact, when we carried out the impact assessment, the farmers earn more than 20% of their income. So initially we started with 7,000, now we have gone to about 50,000 farmers now. We are, for one particular crop, where we deploying different technologies. That's one aspect where we are helping farmers. The second one is, it's about women. We have called small self-help groups, very poor women, where government gives them loans to start their own businesses. So they actually use this money for the business and pay back the government at a very low interest rate. So, but these poor women, even though they do well in their business, they're not able to get loans from the banks. Because in order to get a loan in India, I'm sure it's elsewhere the same, they need to submit a collateral. Poor people, they do not have anything else to show as a collateral. So what we did was, we used blockchain technology to assess how that woman is actually, these women in that group are repaying, So we are developing a credit score. And the government is issuing this credit score to poor women. So once that credit score is issued, the banks can actually use that, look at, okay, she's repaying her loan well, I can issue a loan. So that's another solution that we have developed to address, the financial loans that women are not able to get. That's the second one. Third, there is we have what you call, chit funds. It's a financial instrument. It's a borrowing and saving instrument, where low-income group people, they put their money in that. It's a pot kind of thing. They put their money and they just take it back after it accumulates after a couple of months. Most of the times what's happening, a lot of scams happen in this. People just take away the companies, they put up that chit fund company, take away this money and run away, So we have implemented a blockchain solution that actually alerts the government official, the regulator, well in advance before such scam happens. So today we are able to save, so many thousands of people lives who have actually put in their money. So that's one. And a very interesting project that we are recently, the senior advocate was also talking about the driving test, right? Trust is the driving. This is a very typical example. We have India. In India, deaths due to road fatalities is the highest compared to US, China, any other country. It seems the record says every 3 minutes a person dies in India because of an accident. And these are young people who are dying, so on the roads, productivity, people who are going to be productive, who are going to add to the GDP, to the economic wealth of the country. So, so much enforcement has been done, so many laws are there, but nothing is able to prevent these accidents. So we thought, can we use technology to actually address this problem? So we actually installed AI devices on the road transport buses that actually alert drivers when an accident is about to happen, when he's overtaking, when he's fatigued, when he's just dozing off, alert comes in. and tells the driver. So this, in fact, after the 6 months of setting up this, the accident rates have come down by about 40%. So, so these are we call it as population scale problems, using this AI has been used. So these are the kind of problems that we are solving using, technologies. So, it's like citizen movements happen because a problem, exists there. So our approach is, can the government proactively, identify problems before they're blown out or snowball into major controversies is what we do. So in this way, the last one that I want to say is again social benefits. Most of the benefits that the government actually gives to the people, they do not reach the last mile. So I'm not sure how many of you heard about Aadhaar. It's actually a unique ID given to every citizen, every resident of India. Earlier, there was no way to identify a person. Like for well-to-do people, we have bank accounts, we have addresses, but people living in slum areas, they do not have an ID of their own. This Aadhaar gives them a unique ID, and they're also advised to open a bank account. So whatever benefits that the government is now actually want to give it to the people, they're directly transferred to the bank accounts. And in Telangana, we went one step ahead, and we are using one tool where we actually, AI tool, where we actually identify the right beneficiary, whether he or she is eligible for this benefit, and then we give those benefits to those, people. So this actually plugs so many leakages, and it saves money to the exchequer. And most importantly, these benefits go to the right beneficiary. So that's what we have been doing. I'll pause here. Probably, yeah. A few more examples later I can share. Thank you.
Thank you so much, ma'am. The conversation is not just about AI, and we are really glad seeing how some states are using AI for the benefit of people. Dimas, in Kenya, there is a lot of digital tool use and social media platforms, especially for civic engagement. And you see the advent of digital tools and social media has really transformed how citizens engage with governance issues, and platforms such as Twitter, talk about WhatsApp, Facebook. So in your view, how has digital tools and social media transformed civic engagement? And what are some of the challenges that perhaps even as civil society we face in ensuring that there is ethical use of digital tools within the civic space?
Thank you, Geoffrey. Because I know Apur is about to run, so I'll allow him to talk about Internet Freedom Foundation and in the context of digital tools and internet shutdowns before I proceed, okay, because I know he's
that's fine.
He's pressed for time.
So welcome, Apar.
Thank you so much. I had scheduled a client call at 1 noon, and I thought the only person who would be unhappy would be my stomach, because I would be intruding on my lunch. Really sorry, I couldn't stay for the entire duration of this panel. Before I commence with just telling a little bit about the kind of work we do on ensuring that the constitutional framework leads to an assimilation of technology that furthers goals under the Constitution, would like to also tell you a little bit how that work is conducted. So under the Constitution in India, broadly, I think you may find certain parallels of what exists in Kenya. You have the legislative branch, which makes the laws. You have the executive branch, which enforces it. And you have the judicial branch, which hears quite often challenges which are premised on judicial review of the laws as well as the executive actions. Now, quite often, when we look at technology, we do look at it with a sense of opportunity and what it offers to us in terms of tangible benefits, especially for the global south, which looks towards addressing a large amount of the social problems which exist in our societies. And here, for instance, teleconnectivity and the smartphone offers people the ability of mobility, not only through their devices, but social mobility. A poor person can, through remote learning, remote health, avail certain facilities which were not traditionally available to them. And here, the smartphone and internet is no longer viewed merely as a convenience or a business function, but intrinsically linked to all of our lives. Now, in this recognition, if you just look at the teleconnectivity statistics in a city like Delhi, there are 3 broadband connections for every person. There are less people, there are more broadband connections. But that does not mean that every person has a broadband connection. Apar Gupta will have 4, but a person who provides a blue-collar service, let's say in any of our houses in terms of housework, may be a family which is sharing just one smartphone device. So the very base of digitization, whenever we look at it, has to be in terms of access and overcoming the digital divide, which links to a constitutional value of equality before law, which I think is a shared value between many post-colonial constitutions. But it is also incumbent quite often, which we have seen in post-colonial countries, is that the legislative and the executive branches are still growing into that democratic framework. It's not as if you adopt a constitution and from the very next day, the lawmakers start imbibing a democratic culture. These cultures are built over time, which is a recognition of why the judicial branch conducts judicial review, is the law which is passed as per the powers of parliament. And I think Kenya here has struck down a compulsory biometric system which was called coercive as unconstitutional. Unfortunately, I was part of the Supreme Court challenge in India, and I think the dissenting judgment did provide value to the Kenyan Supreme Court subsequently. However, I would personally refrain from expressing opinion. I was a lawyer in that case, but I guess you can see the expression on my face. But the benefit of these kind of cases quite often is also a form of incrementalism, where we learn from the past, in which the win and losses may be immaterial, but we learn from the past. And here, I would just like to talk a little bit about internet shutdowns and the work my organization does. So I practice law, and there was a vacuum we noticed in India where there is a lot of capacity building. There are a lot of organizations in India which conduct research, but pure play advocacy, or what is called strategic litigation, parliamentary engagement, policy processes in which you participate in a public consultation, file RTIs, or also align with citizen movements when they ask for certain forms of economic or social justice, is absent. And quite often these movements do face a form of censorship. I'd just like to illustrate how we have done this work at IFF on internet shutdowns. Internet shutdowns were being done in India since 2013, especially on issues of internal security. And to a large extent, the people did not really mind this was happening. And these were being done under curfew powers under the Code of Civil Procedure, as well as the Indian Telegraph Act, which is, I think, so similar to the Telegraph Act, which exists in a lot of post-colonial countries. It was a British law. It's been changed now, but the provision is the same, which also allows an internet shutdown. Now, the problem which was occurring was that people were not informed why the internet was shut down. A legal order under that was not published with the reason stated why the internet is being shut down, from when till when. And if we look at international human rights instruments, an internet shutdown is somewhat of a hammer rather than a chisel. It is disproportionate. So the doctrine of proportionality, which says that, okay, if you want to prevent an issue of internal security, you ban these 10 websites for this period of time, does not apply to an internet shutdown, which is a complete blockage of the internet itself. So when the internet was shut down in Jammu and Kashmir, certain petitioners approached the Supreme Court. We assisted some journalistic bodies, and the Supreme Court gave a decision that there needs to be a published legal order which needs to have reasons, and an internet shutdown cannot be indefinite. Even subsequent to that, this form of transparency has not led to accountability immediately, in the sense of people then getting these orders, rushing to court and challenging them. But what have the other branches of government done? The Parliamentary Committee on IT has published a report on internet shutdowns and has said, what are the economic justifications? Does it actually prevent violence? Is there any economic study? of the costs which come through it, because you can't even transact through what you hear about quite often, the UPI. And India, as per civil society sources, has the number one, the bad rank of being number one on internet shutdowns, right? And India shouldn't be on that list, according to me. We are a world leader on digital technologies. And I think so this has led to some form of recognition and reform over a longer period of time. I think internet shutdowns are done not only for internal security, they have also been implemented for preventing cheating in exams. They have been implemented to prevent citizen protests on smaller issues. And I think that this is something which also impacts people who are in blue-collar professions, who are gig workers, who are part of India's larger Digital India program and rely on social security benefits. IFF has done one report with ground surveys in Rajasthan, which is an Indian state, in which we asked people how do internet shutdowns impact daily wage laborers, people who work in the gig economy, for instance, an Uber, a DoorDash, a Zomato, a Swiggy, those food delivery apps. I would like to end by stating that there's a great degree of what Commonwealth jurisdictions learn from each other. As post-colonial countries who are growing into a culture which is democratic, hopefully, it's not uniform. We take 2 steps forward, we dance a little on the side, we come a little back, we do a little jig all the time, right? But there's something to learn between us. And the great benefit is our Supreme Courts also signal to each other, and they read each other, right? So if you are ever looking for any opportunity in terms of Indian precedent on the intersection of law, democracy, rights, and technology, please do reach out to me or my colleagues at IFF. We have conducted close to 54 strategic litigations on a wide array and canvas on digital technology and how it touches upon fundamental rights. Thank you so much.
Thank you so much, Apar.
I will have to now make a...
Okay. Thank you for your presence and taking your time to join us.
Thank you. And just before you leave, so 2 weeks ago, Kenya was going through a national examination, and Telegram, the platform, was blocked because of allegations that it will slow down exam cheating. This happened also last year. During the Gen Z protests on 25th of June, from 4 to about, for a period of 5 hours, the internet was also shut down in Kenya, affecting some parts of Burundi and Uganda. And the government, not the government, but one of the larger service providers, Safaricom, claimed that it was an undersea cable that cut. But after 5 hours, that undersea cable was repaired. And it was during the worst protests that we have seen in a long time. And so for many years, we thought that internet shutdowns was not something that Kenyans needed to worry about. But now we find ourselves in the company of India.
There's a lot of jurisprudence which is developing in India.
Yeah.
Because sometimes there are state concerns which need to be accommodated. So India, due to these unfortunate practices, has developed a body of jurisprudence where our judicial branch has instilled some forms of accountability. I'm happy to share notes or to share that precedent, those judicial decisions. And it's unfortunate to hear about this, but it also shows that society in some way is in a flux. I think internet shutdowns are a representative sometimes of a gap between people and the government, which can be bridged through better communication. I think so. That there needs to be emphasis on, rather than shutting out the voices of people, to hearing them and then building trust.
So thank you very much. We'll really benefit from that precedence. Thank you. So to go back to the question that you had asked, yeah, so digital tools are quite vital in terms of citizen participation, especially on economic justice issues. And looking at what happened in Kenya in June and July, it speaks for itself that the online space, the digital infrastructure, that ironically was set up by the government itself. You know, the fiber optic coverage in Kenya is better than most countries in the region, in the Eastern African region, which has also translated into a very tech-savvy young population that use the internet for so many things, including some things that are maybe not very good. For example, there was a study that showed that Kenyans were writing were doing research for American and British students for PhD and master's level, which is cheating, right? But this is something that they're doing, and it's a way of living for many people in Kenya. However, there are things to learn from, for example, what happened in June. So if you look at the tools that the government used to perhaps silence critics or to just block the space, was number one was that shutdown. I'll call it alleged now until it is established that it was really a shutdown. But the other one was the use of the Computer Misuse and Cybercrimes Act, specifically sections 22 and 23. Section 22 speaks to publishing false information. Section 23 is publishing false information about a person, so that it's sort of something similar to criminal defamation. Ironically, the Cybercrimes Act came into force in 2018, and the courts, the High Court at that time, had struck down criminal defamation the same year. And so the same year when criminal defamation was struck down, a similar provision was brought back by Parliament. And I don't know whether you can remember, this was the time that there was an allegation by a female, there was a story about female MPs and a certain young man. And if you look at the Hansard, the MPs had said that they will show these bloggers that they cannot really talk about us the way they want. And if you assess who has been arrested under this law, it's usually people who speak truth to power, and the recipient, the person who's allegedly complaining is a person in government or a person who can be said to be powerful. So recently, even someone posted a photo of a casket and alluded that it was someone powerful in the country. That person was arrested and charged under this law. Funnily, no one has ever been convicted under this law. Mutemi Okiyama, in 2020, published a public warning to IMF saying that no one should loan our former president any money. He is persona non grata, arrested under this same provision. And so you find that there are laws within our statute books that are really stifling the space where actually people engage with governance issues. If you follow certain platforms in Kenya right now, Twitter, for example, Kenyans are looking at public documents and translating it into, and actually visiting the ground, visiting where the purported public projects were done, and they find that the project was never completed or never even started. This is digital tools being used to demonstrate how the country is being pillaged in real time. And also, I see another issue with the Cybercrimes Act, those two sections, is that it turns the government into the arbiter of truth. You know, we all have freedom of expression, but there is nothing in the Constitution of Kenya, for example. Article 33 gives us the right to seek, receive, and impart information and ideas, regardless of frontiers, you know, and in any medium. But also proceeds to say that freedom of expression does not extend to propaganda for war, incitement to violence, vilification of others, hate speech. And also says that while exercising freedom of expression, you need to respect others' privacy and reputation. Nowhere in that provision has it said that freedom of expression does not extend to lies. And, it doesn't say that. And we have precedents in Kenya, especially since 2014 coming up to now, that has really upheld freedom of expression. And through this process, and these are cases that I was personally involved in, criminal defamation was struck down because the court said that the prospect of a journalist, for example, being arrested, having to look for a lawyer, having the prospect of looking for bail and bond, and then may actually be imprisoned for writing something about someone else is disproportionate. Then there was Section 132 of the Penal Code, which creates the offense of undermining authority of a public officer. This case was brought about when Robert Alai spoke about something the then president, Uhuru Kenyatta, said about Raila Odinga. And Justice Mwita said that this is preposterous because you need to be able to talk about the people who lead you. And then there was one called misuse of a licensed telecommunication device, which basically said that you can be imprisoned for up to 2 years for using a device to send a message that causes anxiety to someone else. And that was struck down basically because the court said that anxiety is not, it's very subjective. And for you to limit any fundamental right, that limitation must be written in law, must be necessary and proportionate, and must pursue legitimate aim. And so when we talk about internet shutdowns, is it proportionate? When you close Telegram for everyone because there may be students cheating somewhere, is that proportionate? So these are some of the discussions that we are having.
Thank you, Dimas, for highlighting, the importance of safeguarding digital rights to protect freedom of expression. Allow me to go to you, Judge. And we've had cases of internet shutdown, freedom of expression, and all these ideals speak about constitutionalism and the rule of law, because there are also cases where courts have issued orders which are favorable to the citizens through public interest litigation. Yet such orders were not heeded to by the government. So coming to you, how do you see from judicial lenses some of the achievements or other challenges that pertain to constitutionalism and rule of law with respect to citizen action?
Thank you. That is a difficult question from the side of the judiciary, because once a judge issues an order, whether it is obeyed or not, it's not the business of the judge. It is up to those people who ask the judge for that order to come back and ask the judge for enforcement. So the burden of the judge always ends with the request by the parties. Once you write your judgment, of course, we also listen to the media, see the reactions of the citizens, the politicians. Sometimes they will outrightly say they are not happy with that judge, and sometimes they will even name them and say they will not obey the order. But it's not the business of the judge. The judge is through. They will just wait for the person who got the order to their benefit to come back and tell the court to enforce the order. We have our powers, which are also subject to the executive. For example, in contempt proceedings, if you jail somebody, you still have to expect that the order will be enforced by the police arresting that person and taking them to jail. The judge, again, will not take that person to jail, but they will end with that order that I have committed you to jail. But whether or not that person goes to jail, the judge has no control beyond that. Then it's also up to that other person to come back and say this person never went to jail. and the judge will still repeat that. So basically what I'm trying to say is judiciary cannot work in isolation when it comes to enforcement of these orders and of the rule of law. It has to get assistance from the citizens and also the executive. I'm told in other countries they have the court bailiffs who are able to take you to that jail. The court bailiffs will be the one to take you to jail. But in Kenya, we don't have those court bailiffs, but maybe those are issues we may want to think about as we progress as a democracy. We are not yet there. Maybe if you can just allow me to say something about use of digital for the judiciary, now that we are engaging with other in international level. Judiciary has really deployed digital for the purposes of court access and automated our registry. For you, now we do not allow physical filing of any document. Everything is automated. You have to go for e-filing, whether you are the police filing, whether you are the Attorney General or the DPP filing a new case, whether you are in prison assisting a prisoner to assess the court, and of course the litigants, the lawyers know now we have the e-filing system where you have, it is an automatic way of assessing the court through pleadings. Then we have the case tracking system, which is the automated registry of the entire judiciary. Every court now is automated fully in terms of filing and in terms of tracking. I am able to track a case from initiation to disposition. I am able to know when the case was filed, what orders were given by any person in that file. Unlike previous before, where even some parties would mislead the judge that they appear to be pretending it like it's the first application. Now we are able to know whether another order was given in that file and who gave the order. I'm able to know if the file went to the deputy registrar and they gave any order. I'm able to know when directions were given, what directions were given, and that has really assisted the court to weed out corruption, whereby we had issues of missing, even sometimes the ruling would have been written, it would have been plucked out, it is nowhere to be seen. I'm sure some of you have even had experience where the judgment was missing, and or even other proceedings of the court were missing. So with automated systems, we have been able to do that. Now the issue of shutdown of internet. I think Kenya is now lucky because the judiciary is automated. It's automated. If you realize that it was allegedly switched off at 4, the courts were through. So if you switch off the internet in Kenya, judiciary will not sit because we are automated. And I think that is a good way to cushion the citizenship, because the government, the executive is a big user of the judiciary, because suspects are on arrest. During week, they have to be brought to court within 24 hours for charging. So if you switch off the internet, you will be breaching the constitution itself for the rights of those citizens who you have arrested all over the country. The cells will become very chaotic because these people are likely to riot. So I think the fact that judiciary is automated is cushions against these actions of like switching off the internet. Because if you switch off the internet, the judiciary then will just be grounded and everything will not work. And the executive will be also in trouble because they have now to deal with the people they are put in custody and who need to be in court. So I think that is a plus. Kenyan judiciary, without maybe any intention, by coincidence has now shielded the Kenyans from being switched off internet. I think that was not the intention, but with that being in place, the fact that the judiciary cannot operate and you cannot come, you can't even file, you can't file a charge. So the accused person cannot be brought to court because there is the e-filing. We don't have physical filing. So you see now, because of that, we have shielded Kenya from being switched off, especially between the working hours of the judiciary. Thank you.
Thank you. Thank you, Judge, for that wonderful highlight of how the Kenyan judiciary has integrated digital tools and technology into their systems to also protect the citizens. Sid, coming back to you. Of course, with the benefits of digital tools, which have been used to empower citizens, there are also risks of censorship, surveillance, and suppression of dissent. And when you talk about internet shutdown, it is often used by the government to try and stifle dissent, especially during protests, when they realize that citizens are getting agitated. They try and shut down the internet, which is a threat to democracy and human rights. From your perspective, and having been with the Commonwealth Lawyers Association here in India, what are some of the strategies that you think can be employed to hold governments accountable for internet shutdown, also just while ensuring that there is protection of democratic rights and maintaining public safety?
Thank you for that question, and I'm glad to be a part of this panel. And I think when we talk about internet in the present times, like today, internet has become a part of our life. Like if we have to book our cab, or if we have to pay for our hotel, if you are using any mechanism, we use internet. And internet is such a thing that recently an American judge in a case with respect to internet has held that if an alien is to visit us from Mars, and if he comes and inspect human body, he would conclude that mobile was a part of human autonomy. so that has been the kind of the prevalent circumstance with internet and mobile. But when we talk about democracy and the three bodies, which is the state, which is parliament, legislature, and the executive, so all three have to work together. And when we look at whenever a law, like as Apar mentioned, that in 2013 for the first time, internet ban was introduced. So during that time, there was a lot of deference to the executive actions, because there have been circumstances where in India there have been communal tensions and there have been circulation of fake videos. So in order to prevent that communal tension into flaring up, the government has the government has taken steps to curb the internet, and the court have given deference to the executive actions, because there are 3 laws in India currently that deal with internet suspension. The first one is the old CRPC code, where the executive magistrate in India has been given the power to issue a order where he can pass an order that internet may be banned. And then it can be banned. However, it is a requirement under the law that it should be published, the order under which it is being made. Secondly, there is another law, which is the Telegraph Act, which Apar mentioned. And the Telegraph Act also provides a special mechanism wherein maximum number of days where you can ban the internet is for 5 days, and thereafter there has to be a review by a committee, which is to be done by a member of the central government. And the third act is a special act, which is the Information Technology Act of 2002, where there are rules which have been made under the act which provide for suspension of access to the internet. So there are the 3 rules which are there in place. And in fact, in 2016, when I was just freshly graduated from the law school, I had come in touch with Apar Gupta, and Apar Gupta was that time working on a writ petition before the Supreme Court that the power to curb the internet should not be exercised under this old CRPC, because it is an act which gives power to a specific person, which is the state, to block the internet. However, and it should be done either under the Telegraph Act, where there's a mechanism, or the IT Act, which is a special law. So general law should not prevail over the special law. But we moved to the Supreme Court, and the Supreme Court said that there are existence of concurrent powers. So basically, when the problem is new and problem is very problematic, then during that point of time, even judiciary pays some deference to the executive action, because the threat is real. For example, even if we look at the American Constitution, the First Amendment guarantees absolute right of freedom of expression. But even there, the judiciary have decided that even when there are no express limitation in the constitution, that does not mean that there is no limitation at all. And one famous judge, Justice Oliver Wendell Holmes, in one of his cases, has said that if a person falsely shouts in a cinema theater that there is fire, then it is going to cause panic. Therefore, such type of speech, which leads to clear and present danger, should not be allowed because it may lead to tensions. So when we talk of internet ban, the first landmark case in India was decided in 2019 by a high court in the southern part of India, Kerala, where a lady student in a hostel was prevented from using mobile phone and internet during the night. So she questioned that before, and she was asked to leave the hostel in the college, and she was suspended. So she challenged it before the High Court. And for the first time, the Indian High Court recognized that use of internet is and can be considered as a part of fundamental right, because Article 19 of the Indian Constitution, just like the 33 of the Kenyan Constitution, recognizes right to freedom of speech. And freedom of speech has also been discussed to include right to receive information. So a person uses mobile phone, internet for various purposes. For example, education has become a tool, and you can educate yourself from phone. So the High Court in that case said that there cannot be a ban on internet because it is not reasonable. So when I say reasonable, Indian Constitution provides for any limitation that can be imposed on freedom of speech has to be reasonable. And by reasonable, as Demis rightly mentioned, that it has to be proportionate. So when we say proportionate in 2019, there was an internet ban for about 213 days in 2019 in the state of Jammu and Kashmir, because there were some changes, delimitations were done in the state. So when this happened, the petitioners questioned the ban in the state before the Supreme Court. And in that case, the Supreme Court said that what are the reasons existing to suspend the internet? And they said because the ban has been there for more than half a year, there have been subsequent changes and subsequent reasons that have been for which the ban has been imposed. So the court said that in order to recognize the right, in order to recognize that whether a ban on the internet has been done in proportional to the fundamental right, there should be a right on the part of the people to know that there exists a law and there is an executive order, because this will allow the people to know that why the ban has been imposed. And secondly, it will also allow the people to question it before the court of law, because if you do not know that whether, like for example, like Appa mentioned that there have been instances in India where even for cheating, or prevention of cheating in examination, internet ban has been imposed. So to challenge that or to check on exercise of power being valid or not, the court in 2019 have said that every order the executive passes for blocking the internet should be available to the people to challenge. And similarly in 2021, because now this is the time where there has been a significant change, because COVID took place and technology, digital democracy and everything was being done on the internet by the people, and it became a very important part of our lives. So that time also there was a imposition of internet ban, total ban, because there are two types of ban that exist, total ban and partial ban. In partial ban, the speed of the internet is reduced, or their mobile internet is not allowed, but Wi-Fi can be used. So there the court said that if you have a problem that certain messages would be circulated on the internet, so you can only block certain websites, but not complete internet, because everybody uses internet for different purposes. Because during COVID in India, schools were shut and schools were only being run through internet. So supposedly in certain, like for example, Facebook, WhatsApp is not where the education takes place. So the court has said that you have to narrowly tailor the restriction on the freedom so that you allow people to access the internet, which is essential for the livelihood reasons. Then again in 2022, another protest took place, and in that case, the court has asked the government that what are the reasons to impose the ban, and it was in the state of Guwahati where there was a ban on the internet because there there was protest happening against the imposition of a particular act, which was a Citizenship Act. So in that case, the court asked that what are the reasons to block the internet? And government had replied that they have got certain information that in the coming times there would be a protest or there would be violence. The court said fundamental right cannot be curbed on the ground, that there would be an incident which take place in the future. So you cannot curb the internet today to prevent a situation which is unforeseeable. Therefore, the court said that there are no reasons that exist currently to block the internet. So now to answer your question, Jeffrey, that because the internet problem was very new, the court has paid deference to the persons, but now finally I think the court have developed a standard to keep a check. If a dissent is being stifled, there the court can intervene and declare it to be unconstitutional.
Thank you. Thank you very much, Sid, for that comprehensive presentation. I will give each panelist just 1 minute to wrap up, and then we'll have like 10 minutes plenary, and then we'll close.
Yeah. While I did not mention about the downsides of AI, there would be. Hello? Hello? Yeah. I did not mention about the downsides of AI earlier when I spoke about the potential advantages of AI. So there could be biases in the data that we actually use in the algorithms. These algorithms can exclude minorities, marginalized communities because of the kind of prejudices the data has. So be aware of it. Second one, misinformation and disinformation, is being spread using AI. It can actually be done at a very high speed. So there are strategies that we can put in place in order to mitigate. And thirdly, now we are talking about digital divide, but later in the coming years, we'll be talking about AI divide. It clearly, separates between people who use and know AI with the people who do not know AI. So as a government, responsible government, we need to actually ensure that not just the technical people who understand AI, but the general public also needs to understand how AI impacts their life, how it can be used, and so on. So at a population scale, this AI awareness programs will have to be taken up. And lastly, before I conclude, I'll just say one thing. We are talking to our High Court, about how AI can be used within the judicial system. So they came up with certain very interesting use cases. I thought I'll share it with you. Probably you can also think about it. In India, especially in our home state where we speak Telugu, most of the population, they do not understand English. But our judgment is delivered in English. So they said, can you actually use AI to translate these English judgments into our local language? So we're using AI for that. Second, in India, there are tons of, hundreds of thousands of cases pending before the courts. Can AI be used to quickly dispose them? So one use case that we are working with our High Court is, they have about, 35, some hundreds of thousands of cases that are related to land disputes. So they said, can AI be used to group all the similar cases so that the judge can quickly, okay, these are ABC, 1 to 100 cases are similar in nature. This is a judgment I can easily dispose of. This is the second use case that we are working on. Third, when the judges deliver, that is again typed, in a shorthand language we call it. It's written, then typed. It takes a lot of time. They said, can we use speech-to-text technologies? As and when the judge is delivering, it should be automatically, the judgment should be come out as a document. And lastly, most of our layman, we do not understand the legal language, right, to go through the document. Can AI just read the judgment document and give the gist of it to a common man to understand? So these are different use cases that we are working on in the legal space. So lastly, AI has the potential to actually ensure, enabling economic justice and social justice to the marginalized communities. So going forward, I think this technology needs to be leveraged by various governments to ensure that. Thank you.
Thank you, ma'am.
Thank you. We actually in Kenya, we are now leveraging on AI to transcribe proceedings. We are doing tests in 2 courts. There's a pilot program running. whereby the proceedings are transcribed because we are online. You have realized judges, they hear cases virtually. So as they speak to the machine, it's recording and the transcribing, and it's being tested in 32 courts. And very soon, we may have to do away with the handwritten proceedings. And that will really assist because, you know, one of the reasons many appeals are pending is because of lack of typed proceedings and the certified. Some of us have terrible handwriting, we write like doctors. So you find even your colleague cannot read your handwriting. And even the secretary cannot read, even the clerk cannot read. So because of the movement of judges on transfer, if you inherit your colleague's proceedings, you are unable to follow. That means the case has to pend until the typed proceedings are produced. Now with the use of AI to transcribe and automatically proceedings are produced, it will be much easier then, because now we'll move faster, the appeals will also move faster, and I think that will be good for judiciary. So we are already leveraging on AI. Other than now automating the registry, we are moving towards the dealing with the issue of proceedings, which have been a traditional cause for delay of justice at appellate level, whether you are appealing from the magistrate's court to the High Court or from the High Court to Court of Appeal. I think Court of Appeal is already automated in terms of the proceedings. So the problem is at the High Court level, courts of equal status, and the lower court. So we are hoping now, once we are able to clean up that technology and it works for the piloting 32 stations, we'll then be able to roll out to all the courts. And this will really assist people in the prisons, because some of them are staying there for very long, waiting for typed proceedings. So really we are hoping to leverage on digital technology to be able to fast track justice system in Kenya. Thank you.
Thank you, Judge. And Dimas?
When we talk about AI, sometimes the biggest concern is that it's a very technical field. And so when you talk about, for example, the AI may produce bias, perhaps you need to explain that a little more. And let me give facial recognition as an example. So most AI systems rely on training data. So for example, facial recognition relies on recognizable points on faces. And so you train it using real faces initially. And so what happened is that it was realized, for example, in systems, in facial recognition systems in the global north mostly, especially in the west, that black people's faces were either not recognized as faces or misrecognized, right? So there was an error. Simply because the people who trained this data and the faces that was used to train them were white faces, yeah? And so that's a source of bias. Another source of bias may also be cultural, because things work in an X way, so as you're training that data, that is how you assume things would flow. But in a different context, that would not be true. Yet, we are using AI to make very important decisions, including on whether you qualify for social services. In other countries right now, your bail and bond is determined by an AI system. And so if that AI has biases cooked into that, then you see it just reproduces injustice. Another issue with AI is that something called the black box, which means that, and this is because AI uses a lot of programs on top of other programs and hardware from different areas. And so sometimes you can feed an AI system with a decision, with data for it to make a decision, but when it makes that decision, there's no way of knowing how it made that decision. So it's almost like a god, where, yeah, you know, and that's called the black box. And till now, no one knows how to solve that issue of the black box. with regard to digital public infrastructure, ICJ currently is involved in a litigation against Tools for Humanity. I don't know whether you remember the WorldCoin issue of certain people who descended in Kenya, but they were rolling this globally, and they scan your iris. So it was a digital ID based on your biometric data, your iris. Then it uses blockchain technology to give you a cryptocurrency account. And then in Kenya, they also would deposit $55. So by the time we noticed, about 300,000 Kenyans had already given their data. And this was before a data protection analysis has been done, a human rights analysis has been done. And so as we roll out these digital public infrastructures, I think it's important for us to really do assessments, and the courts have been very pivotal in setting standards and actually safeguarding Kenyans' rights. So you remember in Huduma number, the first iteration, the court said we need a data protection framework. Then the second iteration came and the court said we need a data protection impact assessment. And as we continue, we're building law and ensuring that Kenyans' rights are safeguarded in this digital age. Thank you.
Thank you, Dimas. And finally, let us finish with Sid, and then you can ask your question, Mr. Gupta.
So just to, like, as Lady Justice rightly mentioned, that AI can be used as a tool to reach out to the people who are marginalized and being kept in custody for a period which is much more than the time of their conviction or imprisonment. So in India, last year, the Chief Justice has inaugurated a program that through AI, they would keep a track of the prisoners and the amount of time they have spent in jail, so that whether they become rightfully eligible for remissions, they would be given ipso facto rather than they applying to the court. So it was an important initiative taken by the Chief Justice in India. And secondly, I think recently I was speaking at an event for AI and in public law reasoning. So whether the decision-making power can be shifted to a machine, in which after much deliberation it was discussed that because in human rights decision-making, emotional value is involved, and you require a judge who can understand the emotive value of a legal argument. Therefore, that right cannot be transferred to somebody who's not a judge. And for that, even recently, the European Union has come up with a AI Act of 2024, where they have clearly stated that it can only be used as a tool in assisting the administration of justice, but decision-making cannot be shifted or given to a body which is not human, because you require a human oversight over it. Why? Because as Dimas rightly mentioned, that there are biases. There are things because it depends on data, and data can't come from anywhere. So in concluding, this is the summation that I would like to make. And I agree with everybody. Thank you so much.
Thank you, Sid. Because of the timings and also being cognizant of the fact that our judges need to leave to go and visit the Supreme Court, we will allow a few questions and then we will conclude.
Police cooperation in the use of the same, because I think that is a really, really important and practical solution to something that is affecting many, many countries, not only here in India. In Kenya is a big problem. So I would like to hear more about that. And secondly, the use of AI to translate judgments from English to local languages. Is this already operational? And are there any challenges that you are facing? For example, are you able to get the interpretation, translation correctly? Do you get anyone to verify the authenticity and so on? Thank you.
Now or later?
On that translation issue, I think in India, the Supreme Court of India itself is doing the translations of all the judgments. So that's not done by privately, it's done by Supreme Court itself. Now I had another issue, which, because, internet shutdown people have been talking about, that is what the panelists talked about. Now typically in India, in 2023, there have been 116 shutdowns, internet shutdowns. Now 43 have been for law and order. 24 is because of cheating in exams. 20 have been for protest and demonstration, 10 related to election, and there were 5 other. Now in this situation, when you talk of doctrine of proportionality, you have to proportion the civil unrest or what the things are going on, the illegality part of it, along with the benefit which the other people could lose. So it is from case to case that the judges will have to decide on the doctrine of proportionality. You can't say a blanket rule then say that, look, internet should never be shut down. Or like the essential civil services, maybe at some point in time, they may come out and say that, look, certain services cannot be shut down, and certain services may be shut down. So that's my take, and if anybody has any issue on that, I would love to hear that. Thank you.
Thank you very much. My name is Patrick from ICJ Kenya. I wish to thank all the presenters for the illuminating presentation that they have made this morning and also this afternoon. And my question now goes to Madam Rama once again. I am gratified to note that you're working with primary producers, farmers, and noting that the primary producers are always the people who are disadvantaged in the value chain. I would want to know, even if you're working for government, how your work or how you're using AI and the initiatives that you talk about in the morning to alleviate the plight of the farmers, how is it being cascaded, if at all, to other partners in the Global South? As you know, one of the pillars for South-to-South cooperation is the issue of working together, technology transfer, and sharing information. So are there any initiatives that primary producers in Tanzania or Kenya or other countries in the Global South can benefit from what you're doing? Thank you.
My name is Job Ochieng from Kenya. I'd just like to say a big thank you to our judges for embracing technology under the CTS system which they use to manage court files. It's now possible for a judge to hear you from home on a Sunday, on a public holiday. Though some people were concerned the other day that orders were given on a weekend. But for the users of the justice system, we are very happy that you can access justice even at the darkest time or very early on a public holiday. My concern, however, is shutdowns. The other day, we had a shutdown which looked like human, and the court system was not working. That is a serious threat to liberties, to law and order, and to the Constitution of the Republic of Kenya. So that is something that we must guard against, because somebody cannot just wake up and bring down the court system. So it is something that if we do not check into, somebody will be sitting somewhere and then they decide today we are shutting down the court system. So all the gains that we have made in the last 3 years since Corona will be wiped off. So that is something that we really need to check.
Thank you. Just from what Job has said, something has come up in my mind, and I'm just thinking, yes, it's good we've embraced technology, and maybe we can have court sitting whatever time of the day, whichever 365 days in a year. But also that needs to be, we need to have some regulations, because who deserves to be heard at midnight, and who deserves to be heard midnight on a Saturday, and who deserves to be heard Monday morning at 11 a.m. Because then, you see, if you're going to have people dealing with matters at their discretion, because they can access the system and they can be called and told, look at this matter I filed, there has to be a way, because how does a judge know that you filed an urgent matter on a Saturday night? Unless he's been called and told there's this matter. if we don't have regulations, then it will be very difficult for us to have equal access to justice, because there are those who will be able to access that justice at midnight on 25th of December, while the rest of us will have to wait until 13th January at 11 a.m., you know? So I think there's also that kind of thing that needs to be looked into, because even that technology can be abused. Can we ask questions from the previous session or make comments from the previous sessions, or we're just restricted to this session? Okay. This morning we had very good presentations, one of them from the President of the Court, Justice Musinga, of the Court of Appeal, sorry. And there was the issue of meaningful engagement of citizens. And one of the things that came to my mind is, what does meaningful engagement of citizens entail? We had moved 13 years, and just recently with one Supreme Court judgment, we were moved more than 10 years back. It's about time we had a discussion of, as we the people, the sovereign, what do we want to entail meaningful engagement? Secondly, the judiciary is our last bastion of hope for the people across the world, and particularly for us in Kenya now, we're going through some kind of serious transition in terms of what we are used to, and now we are in a kind of space that we are really not used to. And so we really rely on the judiciary to really stand up for the citizens of the country. And this morning we had some interesting discussions just before this session started. And one of the concerns was that judiciary is not well funded. And what are we doing about it as jurists, as civil society, as the Law Society of Kenya? What are we doing about the fact that judiciary is not well funded? We are quiet. We are not pursuing litigation on that. We are not trying to force the executive and the legislature to ensure that judiciary is well funded. Because the more judiciary is not well funded, the more we are vulnerable, the more economic rights will not be achieved, the more public participation will be watered down, the more all the rights we have gained since 2010 will go down the drain. And I think that, and that was a concern raised by one of the judges who are with us here. And I think thinking about it is quite important. When there's stifling of economic power, then if you don't have a judiciary that can stand up and speak for the people without fear or favor, then there's nothing we will be achieving. I liked what Willie said about the fact that they filed a suit. Will the judiciary stand up to be counted? Thank you.
Allow me, I will be asking our president of the Court of Appeal to deal with the issue of the concern for shutdown of our system, because it is true, I think not long ago we had, I don't know that it was a shutdown, but we were not able, even us, to access the CTS system for some days. And of course, let me just deal with the issue of assessing the CTS, the time for sitting, when can you assess the system. A judge can assess the system anytime, and the judges rarely sleep. You may think midnight is late for a judge to assess the system to deal with a certificate, but the reality is most of them are just winding up their day at midnight and checking out whether there are certificates they have not attended to, because they do not want a complaint the next day that I filed my certificate and it was not attended to. So the judge wants you, when you wake up, you find your order. So the issue is, the system, the way it is designed, a judge can assess it anytime. And normally, when you go to the system, you will go to the portal, which is written. You will not see that from your side, but from my side, I can see it's written, because that is my flat. When I have my own credentials, Justice Musinga will have his own credentials, and Justice Mwangi has his own. I cannot access his order, his file, actually. Like, for example, in my court, I'm court number 9. There is no other judge who can give any order under court number 9. if he goes to my portal and even attempts, because he can see my court 9, even if he is your friend asks you to go and assist, he cannot go to that portal and type on that file. If it is a file, the file is mine. There is no other judge other than when I am not sitting and I've given a notice and another judge has been allowed to make orders on my file who can assess. So it is only me. So if a judge makes an order, just know that is their file. There's no way you can make an order on a file which is not yours. And there's no restriction as the time when you can make an order. Remember now the orders are published online. So what the judge will do is they'll just go find out on the portal written my certificates, what are the certificates which are still pending on my system, and clear them. Because as I said, judges during the day, most of the time they will be doing sittings, and maybe by the time you reach 4, you're very tired. So because you want to give time to really consider these certificates, you may not look at them immediately, and maybe you want to just go and rest according to how your body works, and you'll deal with them at your own time. As long as you meet the timelines, like for example, the law says, the regulation says if a certificate is filed by midday, then the judge must deal with it in the afternoon. So that means if the judge finds there is a likelihood of the delay in the certificates, if they wait tomorrow, and tomorrow, remember again, you are running with a cost list. So you'd rather just deal with these issues before you sleep. So I think that I think it's good, maybe we need to do sensitization as to how we give these orders. This is different from court sittings. Court sittings are as per the law. It's supposed to be daytime. Actually, I remember there was one judge, I think it was just Sangawa, who used to sit, and then one day just Kaminwa just popped out of the window and said, "Judge, it is dark." You know, just to remind the judge the timelines for sitting are over. So sitting is different. You can only sit on Saturday or Sunday with a special permission from the CJ. So you'll have to notify the CJ, I wish to sit on these days. It is the same thing when we are on vacation. You can't just create a course list. You have to notify the CJ that I will be sitting, I wish to sit, and the reason why you wish to sit on this outside the normal days. So the court sittings are Monday to Friday during the working hours. And sometimes you can extend with the consent of the parties beyond 5, with the consent of the parties, especially there are some cases where it is possible. But you have to ask the parties that, can we proceed beyond 5? So I think that maybe I'm just trying to just clarify on the procedures. Issue of assessing the system to issue orders is anytime, but sittings, physical sittings, those ones you have to follow the regulations of the court, and which lawyers are aware of. Thank you very much.
Thank you. Maybe a chance to Ma'am Revi.
Hello. Yeah. Sir, to answer your question on the road transport thing, it's a very valid question. In fact, we implemented on a small scale initially because these are new technologies. We want to understand if it really works and then scale it up. So we initially implemented for 200 buses within the public transport department. And once they're confident, now they've seen the results and now they're scaling it up across the state. In fact, this particular, we have presented a number of use cases to the Honorable Prime Minister of India, all these use cases that I talked about, and this particular road transport solution, he said, it should be scaled up across India. Just as you rightly said, it should be taken to other countries. So, because of the criticality of the problem and the solution that it's offering. Yeah, so regarding translation, for any AI solution for that matter, even in healthcare, it can only augment human beings. So verification is required, but it cut down the time from by 90%. So that's if the machine translates it, maybe 10% of the time a human being can use it to verify and then, pass it on. So, and to the question about transfer of technologies, actually our farmer solutions are being implemented by a foundation called Digital Green. It's funded by Bill and Melinda Gates Foundation, and as I speak, it's being implemented in Kenya actually. Last year I was there when this project is kicked off in Kenya. I was at Nairobi, So it's already happening. just wanted to answer that. Yeah, thank you.
So I think to answer that question, I think because I think when we talk about political sphere, so it's available to every political party equally. And now I think because of the internet reasons, I think because now digital democracy is there and everybody has become a participant in democracy in the sense that everybody is having access to internet, and like the government regularly writes to people informing them of what is happening every day with the changing in the government and what policies are being introduced. Like ma'am rightly mentioned that there have been situations where farmers are being reached out, like direct there have been transfer of schemes. So I think government has been doing good for the people, and there are no as such restraining activities where you would see that there have been stifling, because there have not been any case in India where they have stated to the extent that somebody's freedom of speech was curtailed to the effect that they were not given platform. So I think this thing in India works out well, that availability is equal in terms of accessibility of platform. So that.
Thank you.
I think for me, the only comment will be on the funding of the judiciary. During the NADCO talks, we presented our views as ICJ, and what we're advocating for is funding of between 3 and 5% of our national budget going towards the judiciary. Because actually the judiciary is what would even drive commerce in terms of the speed at which commercial disputes are heard and determined, not to speak to important issues such as access to justice for normal human beings, people in the criminal justice system, and so on and so forth. So just like the way a person's priorities can be deduced from how they budget, how much you spend on on healthcare, what you find important, education, then we should also judge our societies by how they view themselves in terms of access to justice. And we are doing very badly. We are currently way below even 0.5 of our budget.
Thank you, Dimas. Maybe the President of the Court of Appeal can respond to the question as a last response, and then we close.
Thank you very much. I'll make very brief additional remarks to what Dimas has said here. The issue of funding the judiciary is of great concern to us in the judiciary. Let me speak from where I sit. The Court of Appeal, our establishment is 70. Today, with 29 judges, we are operating at 41.42% of our capacity. I had presented a paper to the Judicial Service Commission, even had engagement with the JLAC Parliament, and agreed that really must have resources so that we can employ more judges. And you are aware that even advertisements were done, and in the last minute they had to be cancelled because there were no resources. This is an issue that we must address collectively as jurists, as legal practitioners, because it is hurting the entire country. When I have an average of about 40 certificates, matters being certified urgent every day, and I do not have judges to deal with those matters expeditiously, it hurts me. I feel so bad when someone's property is auctioned before an appeal has been heard and determined. And so I like what we are engaging. Thank you for that question. It is a matter that should concern all of us as Kenyans, as law-abiding citizens. And I pray and trust that we will put concerted effort and pressure, if need be, so that this issue is addressed once and for all. the issue of shutdowns again, and even before I come to shutdowns, when I was chairing the committee on performance management and institutionalizing that kind of system in our judiciary, in our report in 2015, we advised the Chief Justice and Judicial Service Commission that we need to have specific regulations to stipulate how courts can be accessed over the weekends, public holidays. Because you remember those days we used to call Kamata Kamata days. Now that means Fridays when the police and a few other people would round up suspects, you're arrested, and you put in custody. They know that nobody is going to bail you out until Monday. Warn to that person if the following Monday is a public holiday, like the way Easter happens. And so we said there has to be a way of accessing courts over the weekends, even at night, in particular incidents, because administration of justice, just like hospitals, is an essential service. And perhaps we need to know who is a duty judge on Friday night, on Saturday, on Sunday, in the event that there is any urgency to access the courts. So-and-so is on call, and they can be reached. And in these days of virtual working, it is very possible to grant that order on a Saturday night, so that that person, if they have to be taken to a hospital on Sunday morning, they can be taken. I hope something is going to be done about it, because we also do not want to have incidents where our new system of work is abused, and there is selective application and administration of justice where some people are given favorable orders at odd hours. The incidents of shutdown that happened the other day, when we followed up, we do not know whether it was intentional or not. We're told that it was technical challenges, and there are times when you are not able to tell whether it is true or not. Let's hope that it is not going to be repeated. It's of serious concern to us, and the judiciary actually wrote a letter to the organization and the ministry concerned, and we expressed our views. But related to that, I remembered another incident. I remember the swearing in day of our deputy president. I think it happened on a Friday. Is it 1st of November? It happened that together with a few other people, we were going to the U.S. We were part of observers of the U.S. elections. Now, you finish your work on a Thursday. The following day, you think it's a working day as usual. You have a costis and everybody, and at 7 o'clock, people are told that the following day is a public holiday. You cannot access the courts, cannot do anything. And I was thinking about it when I was in the U.S. The day of voting. I think the 5th of November. In the U.S., the day when they are electing their president is a working day as usual. Unless you are voting, you are working. For us back in Kenya, I say, swearing a deputy president, public holiday for everyone. And how many people are involved in swearing the president? It is important to swear in a deputy president. I'm not underrating that. But I just wondered, why make the courts and the entire economy not work? Because we are performing that important task of swearing in a deputy president. Why don't we swear in the deputy president and let I don't know whether, I don't want to call it a selective, anyway, let me not go there. And therefore, as we think about the use of AI, even even the whole issue of working virtually. Though they have very many benefits, let's be careful that they are not abused and we end up losing some of the benefits that we ought to be gaining. We all need to be vigilant and ensure that there is the initial members of the public are involved in each and every decision that we are making that affects their rights. Thank you.
And now I will call on our council member Gishuru to take the next stage of the program. And there is a request that has just come in. Justice David Mwangi is requesting to say something. So as Gishuru comes, you can continue, Judge.
Thank you very much, moderator. My name is David Mwangi, Environment and Land Court in Nairobi. I have requested for this opportunity to say that it is my first conference at the ICJ, and I really want to appreciate it. The choice of topic actually made me come. The South-to-South dialogue on economic justice and climate action. It was very attractive. And there could not have been a better choice than India on such a topic. We do exchange a lot with the Indian courts in matters land, environmental justice. And now, I also wanted to notify our members here, who are also practitioners in our courts, that the Environment and Land Court has also not been left behind in matters AI. We have been having a debate with surveyors, and they told us that we no longer need to have site visits because there is something they are calling geo-referencing. They are able to tell, even in matters adverse possession, when was the last occupation, or rather, when was the first occupation? Has the land been occupied in the last maybe 5, 6 years? We are able to do that without site visit. So I also wanted to say that we are embracing technology, and we encourage debate, we encourage participation of ICJ. There's a proposal to repeal the entire Survey Act so as to incorporate matters technology. Please do not be left behind. Thank you very much.
Ladies and gentlemen, as we draw this transformative 2024 ICJ Kenya Annual Jurist Conference to a close, I stand before you inspired by the depth of the discussions we've shared and the unwavering commitment demonstrated by everyone here to advance the rule of law, meaningful governance, and citizen participation. The conversation on citizen engagement have underscored truth we cannot ignore. The strength of the advocacy of the democracy lies in its people. For governance to be meaningful, democratic processes must actively include the voice of the citizen, both online and offline. This is especially crucial as we grapple with the realities of dwindling public trust in institutions. Now more than ever, those in government must enhance transparency, participatory and inclusive processes to reestablish confidence and legitimacy in government systems. From the Kenyan and Indian perspectives, we have seen how litigation and advocacy can serve as powerful tools to safeguard democracy and the rule of law. Courts have been and must continue to be the guardian of constitutionalism, while civil society and advocates ensure that the people's voice resonates where it matters most. Our role as jurists, lawyers, and defenders of human rights is clear: to relentlessly push for systems that foster justice, equity, and inclusion in governance. We also cannot ignore the significance of the South-to-South cooperation in addressing global dynamics that often leave our nations marginalized. By working together, countries like Kenya and India can influence global systems to reflect our shared aspirations and foster solutions tailored to our realities. This collaboration also provides a platform for the exchange of ideas and strategies to fight the cancer of misgovernance and corruption, which continues to erode development and deny citizens their rights. As we live here today, let us remember that our work does not end with this conference. The insights we have shared must translate into action, whether through robust litigation strategies, impactful advocacy, and cross-border collaboration. We must ensure that our efforts continue to strengthen governance frameworks that are people-centered, democratic, and anchored on the rule of law. Let us hold firm to the belief that when citizens are empowered and governments are accountable, democracy thrives and trust is restored. Together, through our collective expertise, passion and dedication, we can create systems of governance that are that not only serve the people, but are shaped by them. Thank you all for your invaluable contributions, and may we live here committed to the pursuit of justice, equity, and meaningful participation for all. Thank you so much, and now I invite my very good senior, Santan, kindly.
Good afternoon, colleagues. I think our friend really said it all. He has wound up everything in a nutshell. So I don't think I need to add anything. But still, since he has invited me to say a few words, what I would do is, the topics which we discussed, mainly, broadly speaking, two topics. One was global economic policies and accountability in resource management, charting a path to economic justice. And the other one was digital tools in shaping the economic justice. We have heard enough on digitalization. Although we all espouse the cause of freedom of expression, at the same time, when it comes to internet freedom, it has to be there, but the regulatory aspect is very important for all of us to keep in mind. And when it comes to the first topic of the morning, what I observed was, we started off with a keynote address where Justice Musinga was trying to take us through the global south, equitable growth, solidarity, accountability, inclusiveness, and well-informed laws, and ultimately he said knowledge is power. And where he also tried to tell us that economic reforms comes out of the legal framework. So where we are all involved in our own way, and then how digital revolution and AI would give us mainly on healthcare and financial sector. So these are the broad observations that were made by Justice Musinga. And when it came to the topic on global economic policies and accountability, charting a path to economic justice, which was very important, that's the crux of this conference, I feel. We started off with a discussion as to how and in what manner rise of the global south starts basically from relationship based on trust. That's how the conversation began with the statement from Aruneshwar Gupta, where he explained to us as to how trust is the basis of everything, and wherever there is a breach, which will result in either criminal breach or civil breach, and we all land in the court. So trust is very important. And thereafter we went on to hear a very interesting conversation from our friend, I think, who's sitting there, who was basically speaking on how borrowing money, as we all rise as a post-colonial society, and we start the tendency of borrowing from across, and the borrowing money does not reach the shores, and how that results in the kind of litigation. And he shared the experience of both Mozambique and Malaysia, where the persons who committed wrong were brought to books, and how he was espousing that Kenya should also follow suit. So that's very important observation. And towards the end, the question that was posed was, who is a sovereign? Whether the person sitting in the seat because of our votes, or the people as such. Ultimately, for us to draw a conclusion, people as such are the sovereign. There can't be any two opinions on that. But the way we regulate our society assumes importance. So ultimately, we slowly and steadily led to a stage where we were told it's time to act. It is not the time to reflect. From a situation where we are demonstrating, we need to get into revolution. So that was call for action. And thereafter, towards the end, a voice of regulation came where it was suggested, once we understand how the money comes and how the money vanishes and how the money operates in our system, in our lives, once we start understanding this, what we will come to understand is that it is not action in terms of demonstration followed by revolution. Ultimately, everything rests on the judiciary, the judicial accountability, and all of us who are part of the dispute resolution mechanism, we rely heavily on the judiciary and its independence, which will be giving us all the solace. I feel this is the crux of the key takeaway of our discussion today. And as I told you in the morning, relevance of economics, relevance of economic policies, which is directly relatable to the growth of each jurisdiction across the world. So economics is the basis. As we all, whoever has coined this subject for our discussion today, I would say 3 cheers to that person. This has to be the basis of all the legal conferences across the world. And I think we started on a very right note. And I must also add, I was informally talking to some of our friends, including Justice Musinga, that how this happened today, it's some kind of an accident. Somebody got a thought in Kenya, and then all of you came, and then we joined hands, and we have been spending few good hours from the morning. What I would suggest is, let us continue this relationship. Next time you try to do something, and we from India, not only 2-3 of us, a bigger delegation will come over. It can be Indo-Kenya affair. Slowly it can go to East Africa and then the continent as such. Because India and Africa has got lots of commonality, and we need to recognize that. And when we talk of mediation, mediation was the original thing that was there as far as dispute resolution is concerned. Today, all of us are dealing with the court system, finding out who is right and who is wrong, all because of what happened during the colonial time. Post-industrial revolution society gave us this method of adjudication. Otherwise, we were all having our own traditional methods of dispute resolution. The entire African continent had its own way. Similarly, in India and many global south countries had its own way of dispute resolution, which is directly connected to the tradition. So, today in the name of mediation, we are all trying to trace the history back and try to understand how we used to resolve the disputes. So let us not keep that away in this process of trying to find as to how we should march forward in terms of economic justice, and where we think in terms of involving the citizens apart from the lawyers who are very active in this field. So thank you very much for this opportunity, and thank you for all coming, taking your time off, coming over to India, spending some time here, and we will definitely reciprocate. Looking forward to future conversation. Thank you very much for all this.